Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about pretrial service monitoring. But before we get to that, don't forget to click like on this video and subscribe with a little bell next to it if you're enjoying all these videos and want to be notified of future videos. So, what is pretrial services monitoring? And the answer to that is anytime somebody is released on bond, the judge has the ability and often the responsibility, the obligation, to put somebody on pretrial services monitoring. The statute is the best place to start with this. So, looking at that, 16-4105 authorizes conditions on release on bond, and it talks about not committing a felony. It talks about additional conditions: the bond shall not fail to appear, and so forth. There are some specific sections, like here for DUIs. If a person's on a DUI charge with any prior DUI convictions, then the court is obligated to order pretrial services monitoring and monitored sobriety, which involves daily call-ins to make sure that the person's not using alcohol or drugs. The other conditions of pretrial services monitoring are listed here. Periodic, they're all possible, like periodic telephone contact, office visits. Technically, they can go to your home. Of course, I don't think that happens too much here in Colorado these days, but they can also order treatment of the behavioral or mental health problems, alcohol, drug testing, domestic violence, counseling, electronic or global positioning. I'll talk about that in just a second. Pretrial work release and other supervision techniques shown to increase court participation and so forth. So, let's look at the answer that I have put together here. So, pretrial services monitoring could be anything from checking in with pretrial services, GPS monitoring, monitored sobriety, to full-on in-home detention, which I've seen before in Denver. Let me show you an example. This is a case I just recently had where upon his initial appearance in front of the judge, he was given PTS, pretrial services, intensive supervised with GPS unit with exclusion zones. They were trying to keep this particular defendant away from somebody else. And the way they do that is they put the person's home into exclusion zones, and they go from there. I'll talk a little bit more about GPS in another video. But then 2 months later, he was reduced to enhanced supervision. So it went from intensive down to enhanced. And that's what that looks like in a Denver case. So it's never fun to be on pretrial services, but it could just be as much as calling into the pretrial services office after each court appearance, which is most typical. If somebody had some sort of a case that involved alcohol, the judge will often put somebody on monitored sobriety, which involves daily call-ins. If it's a serious case that involves alcohol, especially like with felony DUIs, the judge will often order a SCRAM, which is an ankle monitor, which monitors for alcohol. And again, in a lot of serious DV cases and even some not so serious DV cases, they will issue an order that requires GPS monitoring. Again, it's another ankle monitor, something else to take care of. So that is the question and answer for today. If you would like your own question answered in a future video, don't forget you can always put it in the comments below, email it to me, or tag me on Twitter. And as always, you have a right to remain silent. If a police officer asks you what you've done, where you've been, what you have, or what you know, you always have a right to say, "I don't want to talk to you," or if they persist, "I want a lawyer."